Hello, good afternoon to you all. Boa tarde a todos. Como foi avisado, por causa de alguns nossos palestrantes, nosso webinar hoje vai ser em inglês, mas as perguntas podem ser feitas em português ao longo da apresentação no canal do YouTube, no chat do YouTube, que elas serão passadas aos palestrantes na língua que for conveniente para a resposta. Going back to English, I welcome you all. We are here to discuss arbitration and decisions in disputes involving domain names in Brazil and throughout the world. We will have speakers from WIPO and from the University of Portsmouth. It's going to be a nice discussion, I hope. As you know, we have been dealing with these disputes for over 20 years now. WIPO has the center for over 20 years. We have also, concerning .br domain names, we have other centers like the one handled by ABPI, Associação Brasileira de Propriedade Intelectual, which works very well too, and also chambers of commerce. But I don't want to take any more time from you. I'll pass the word to our co-host, José Graça Aranha, who's going to say a few words. José, the floor is yours.
Good afternoon. Thank you, Álvaro. Can you hear me? Yes, can you hear me?
Yes, it's cutting.
Hello? Can you hear me? Álvaro? Is it better now? Can you hear me?
Yep. I think your connection is not very good at the voice. So we see you, but we cannot hear you because you're breaking.
Let me see.
Now it's better.
Can you hear now?
Yeah.
Okay. So on behalf of, good afternoon to all, on behalf of the World Intellectual Property Organization, I'd like to welcome everyone to this webinar today on the arbitration and arbitration and on domain names, and my colleague, co-organized by AIBPI, so the Brazilian Association of IP Agents and the Transatlantic IP Academy, both here represented by the ABAPI by the president, Álvaro Loureiro, and the Transatlantic IP Academy by Laurent Manderieux, my old colleague, a former colleague who now lives in Milan. We're going to have two speakers, Joe Sexton, a senior lecturer in law from the University of Portsmouth, and a founder of IP Pass, an advanced IP service developed specifically for students and for startups. And my colleague, Luisa Alves, she's a legal case manager at the WIPO Arbitration and Mediation Center. In these difficult times of pandemic, we are organizing events, online webinars. WIPO is fully teleworking. Everyone is working from home, and our WIPO office in Brazil has been managing to reach a lot of people through that. Last year, we had events and we spoke to 10,000 people. This year, from January to now, we reached 8,000 people. So in 6 months and a half, almost 20% less than what we had last year. So this is we are trying to cope with the situation and organizing different topics, different meetings on relevant IP topics, and arbitration is certainly a topic that is gaining momentum in view of the current crisis. So with this welcoming words, I give the floor now, I think, back to Alvaro, and wish everyone a good event. Thank you.
Thank you, José. I hope we'll be increasing the number of people that you mentioned with our webinars. I'd like to invite Laurent Manderieux to join us, and he's going to be the moderator of this afternoon. Laurent, welcome.
Well, thank you for inviting me. I would wish to warmly thank the WIPO office in Brazil and Dr. José Graça Aranha, as well as Dr. Pimentel. And I would wish also to warmly thank ABAPI for organizing fantastic events jointly that would serve the IP community and that would serve development in these very, very difficult times. As director and coordinator of the Transatlantic Intellectual Property Academy, it is my objective to ensure full dissemination of knowledge on intellectual property, showing also society that intellectual property has its drawbacks, but is also extremely useful to promote development, to promote positive objectives for society. This is why when the WIPO office in Brazil, under leadership of Dr. José Graça Aranha, asked me to support and pool efforts in order to promote intellectual property in Brazil and in South America, I was enchanted to do it so and to bring the support of the Transatlantic Intellectual Property Academy. The Transatlantic Intellectual Property Academy aims at creating groups of IP specialists that are stronger on both sides of the Atlantic, the North Atlantic, but also the South Atlantic. And this is why it is so important that the Brazilian IP family be jointly with us today. The big topic that we have decided for today's seminar with ABAPI is related to arbitration in domain names. We all know that the current pandemic brings, of course, a lot of very sad issues in terms of health, which are so painful to all of us, but also brings and will bring many, many additional sad issues in terms of litigation. The current crisis will increase all forms of litigation since self-evidently there have been many, many contract breaches. So no doubt arbitration as such will further boom, will further blossom, because tribunals all over the world will face difficulties in developing. In this very context, domain names play a crucial role, and this crucial role will further be developing. Actually, domain names are simply the business cards of companies. Domain names are granted on a first right, first served system, more or less, and as such, domain names represent the gateway for digital business, but also for the digital page of traditional business. This is why it is so important to think about it. And this is why arbitration is crucial in this respect. But before talking of arbitration, we should very well understand how the domain name system is constructed and how it is enforced. We have today with us two exceptional speakers, Professor Joe Secon from the Portsmouth University, who will talk first, and then Dr. Luisa Berbiger Alves from the WIPO Arbitration and Mediation Center, who will, as such, describe the WIPO system. So I would give the floor first to Dr. Joe Secon before giving it to Luisa Berbiger, so that we have the global framework of domain names and how litigation may develop. And from there, we will study together how the WIPO Mediation and Arbitration Center plays a crucial role in supporting the development of a system that is business-friendly, user-friendly, and of course, in doing so, IP-friendly. So, Professor Joe Secon, the floor is yours now.
Thank you, Professor Laura Mandaru. Can you hear me?
Yep.
Yes, perfectly.
Okay, fantastic. Thank you very much for allowing me to speak on this webinar today. I think Professor Laura made two very important points already. Firstly, domain names act, as I've just made some notes, business cards of companies, and also they act as a digital footprint. Now, before I start talking about the different legal remedies that companies can use in order to protect their domain names, I just want to share a few slides with you which just show the extent of the use of domain names throughout the world. So just give me a second. Can everybody see that?
Yes.
Yep, okay. So I'm just going to turn it into a slideshow. So let's have a look. There we go. Yeah. So again, when we look at domain names, I think the important point to bear in mind, oops, 1 second, is exactly what are we talking about? So as far as I'm concerned today for the webinar, what we're going to be looking at is the name, and here we've got a website, and then we've got circled the domain extension, the .com. So that's going to be the focus. And as Lauren was saying earlier, it's how do we ensure that companies who have a domain name can register that domain name and then protect it if third parties come along and try to use a similar or identical domain name. Now, in terms of domain names, ICANN have developed a number of different types of domains. So we have country code, top-level domain names, generic top-level domain names, which we're all familiar with. And ICANN have been releasing over a number of years new generic top-level domain names. So we have shop, for instance, and there are also geographical top-level domain names. So, you know, going back to the point of, or using the analogy that these domain names are business cards for companies, you can see that companies have a wide degree of choice just within the top-level domain names section. Now, companies, as Lauren was saying earlier, because of COVID-19 and just generally the acceleration of companies wishing to have an online presence, what we've seen is an explosion of top-level domain names. So this graphic here, I think, makes that point very clearly. So we have, and the numbers are increasing, we have approximately 1,584 top-level domain names. Those can be divided into the generic top-level domain names, of which there are approximately 1,269, and then country code. So you can see there that there is a potential for conflict between companies because some companies may want the same domain name. And what's interesting under those headline figures is that look at the number of domain names which, which particular companies have. So we're looking at 207 million domains under the generic and 162 million domains under the country code. So where does Brazil sit in terms of domain names? Well, in terms of the top 15 top-level domain names, the Brazil country code top-level domain name does extremely well. It sits in the top 15 with approximately 4.1 million domains registered under the .br country code. Now, in terms of South America, Brazil sits at the top compared to sort of Colombia, Chile, and others. So I think it's quite important then we start looking at why there has been a huge increase in the number of domains. Now, I thought this is sort of quite important to raise this in the webinar. Domain names, vast majority of domain names can be bought reasonably cheaply. However, as the world, along with Brazil, embrace e-commerce quickly, then we'll see that certain companies will want particular domain names because they feel that their customers associate that domain name with the product that they're selling. So just have a look at the figures here. Carinsurance.com, $49.7 million, all the way down to internet.com, $18 million. So, and these are just examples. There are other examples as well where domain names are selling for huge sums of money. So because of that migration to online, having an online presence, as Lauren was saying, business cards are companies, what then that does, as in other areas of law, generate potential disputes. So what are the common disputes regarding domain names? And I think the most important, and I think most people listening to this webinar will be familiar with this, and this one I've put at the bottom of this slide, is cyber squatting. This is where, and this is just one example, where a company tries to register a similar or identical name with a view to trying to sell that name back to the party who we all think has legitimate use. There are also other disputes, and the first come, first served nature of the domain name registration system also causes problems, because this allows potential third parties who have no direct interest in the domain name to purchase the domain name because they're able to do so. And then we also have, and I'll just talk briefly, not about every single type of dispute, but just one other important one. And that's called passing off. This is where companies try to purchase a domain name with simply the view to try to confuse the customer as to actually who is behind that particular domain name. So what can we do? So later on in the webinar, we're going to have a look at some of the alternative dispute resolution procedures that have been put in place by ICANN and WIPO, which can help companies hopefully get a quick resolution to any domain name disputes they have. But the intellectual property regime can also help us also. So for instance, copyright can potentially help. A domain name, if it is represented on a website or another branding in an artistic way, may be protected by copyright. I mean, there are drawbacks to copyright, but copyright can still be used. And similarly, a domain name, if it is represented quite unusually on a website or on other branding materials of a company, it may allow a design right to be used against a third party. Now, I think we're all familiar with trademarks. Domain names can be registered as trademarks under particular classes of goods and services. So that may be another method by which domain names can be protected. And also geographical indicators can also be used if the geographical indicator is present in the domain name. However, the issue with all these domain name methods of protection is twofold. Firstly, they are costly, and secondly, they can be very time consuming. So if you have a business which is just started and you have to start invoking copyright or design rights or trademark infringement proceedings, you may find that you don't have the resources to actually make your business take off. So one other thing you can do is, before you invoke these intellectual property rights, you could actually write a letter of claim, or what we call a cease and desist letter, which is where you ask for the voluntary transfer of the domain from the third party. So let me just finally finish with some practical measures. Now, having spoken to a number of advocates in this area, there are a number of surprising and unusual things that you can do above and beyond copyright and trademarks and the other intellectual property rights that we spoke about. Firstly, you could do absolutely nothing. Now that does sound quite unusual, but given the proliferation of domain names, you could choose simply another domain name which accurately represents the goodwill and reputation of your business. You could also, as I said, approach the registrant, make an offer for the domain name if that is the domain you must actually have. And I'll talk about approaching the internet service provider in a few moments, but just echoing what Lauren said, you could get in first. It's a first come, first serve framework. So then you could try to, keep alert and try to register the domain name as soon as it becomes available. And they're also increasingly what we call a defensive registration as a strategy. And that is, you try to register every conceivable permutation of your domain, including spelling mistakes and typos, hence the term defensive registrations. Here, what you're trying to do is trying to stranglehold a third party from taking your domain. And the final approach is approaching the internet service provider. If you feel that the third party is using the domain which is contrary to the terms and conditions of the internet service provider, you could write a letter to the ISP asking for that domain name to be taken down. So in a nutshell, there are a number of methods by which a domain name can be protected, and it doesn't necessarily have to involve invoking intellectual property right procedures. There are also, there's the UDRP and the URS introduced by ICANN, which we'll be discussing very shortly. I'll now hand you back to Lauren.
Well, thank you very much. Thank you so much, Joe. I think I shall come back with other questions later on, but I would wish to leave the floor right away to Luisa Berbicher-Alves, who will talk about the WIPO, WIPO dispute resolution mechanism for domain names. Well, we will come back also on questions that I'm starting to receive from the public, so that our speakers may also be able to reply to these questions that I have forwarded to them as well. So Luisa, the floor is yours, and congratulations for being with us from Geneva, from WIPO Geneva.
Hear me well? All good?
Marvelously.
Okay. Thank you, Lahan and Joe, for the presentations. Thank you, ABAPI, for the invitation. My name is Louise. I'm a legal case manager at the Internet Dispute Resolution section at the WIPO Arbitration and Mediation Center. I'll be talking with you today about domain name disputes and a little bit of the work we do at the WIPO Center. I'll ask one of our colleagues to help me with the slides. I think. Can you see this? For me, it's fine.
Well, yes.
So starting with a brief presentation of the WIPO Center. So we we deal with IP alternative dispute resolution services. I'll be talking today about domain names, but we also deal with other IP issues. And we have users all around the world, mediators, arbitrators, and experts in IP. So today we'll be focusing on domain names, but we also provide services for IP disputes in general. So the second slide, I'll jump to domain name disputes. I'll first say that we are very international, and we have parties from 122 countries. We currently have, this number is a little bit outdated, it's 48,000 cases covering 85 domain name disputes. So you'll see that one dispute can cover more than one domain name if these domain names are somehow related. Here I put for you 5 domain name filers, the top 5. So the first one is Philip Morris, followed by Facebook, Sanofi, which is the pharmaceutical company, and Carrefour. Our top 3 countries are United States, followed by France and United Kingdom. Here, then, I put for you the next slide. Sorry about that. This is the areas of WIPO domain name complainants activity. You see that biotechnology and pharmaceuticals, together with internet and IT, are now leading the WIPO filings, followed by banking and finance and fashion retail. So I'll be talking today about the UDRP and the SASI. The UDRP is the Uniform Domain Name Dispute Resolution Policy adopted by ICANN, which covers the GTLDs, the new GTLDs, and some CCTLDs. And I'll also make a comparison with SASI, which we are also providing services for, which is the .br policy resolution. So they have a little, they are very similar, but some differences that we should point out now. We can go to the next slide. So why to file a domain name dispute? So Lauren and Joe were mentioning that the domain name environment is a little bit different than the trademark. So we don't, in the domain name, have like an organization regulating the registration process. So this is a great opportunity to frauds to come up and trademark infringement in general. So we see this every year. We're getting more and more cases, especially now with the whole world going online. And we see that domain names are actually the address of a company in the online environment. So this is a proceeding which is very international. And the UDRP for GTLDs and the SASI for .br. It's meant for clear-cut cyber squatting cases. It is contractually mandated. So the remedy issued by the panelists will be implemented directly by the registrar, but the remedy, which can be transfer or cancellation if a complaint is successful, won't prevent the parties to seek another remedy in court. So even if you have a decision rendered by a panelist in the UDRP or SASI proceeding, you still can go to court. So next slide, we'll go through the 3 elements, first from the UDRP, which is .com, .shop, .online. We have here 3 elements to consider. First, since the proceeding is a dispute that is come from abusive domain name registration, the trademark holder, so the complainant here, should argue why the trademark that it has rights is identical or confusingly similar to the domain name. Second element is that the registrant of the domain name has no rights or legitimate interest in the domain name. And third element, which is kind of different from the SASI policy, is that the domain name is registered and used in bad faith. Next slide is focusing .br. So here we have only the first and third element, and the third element, you need to prove only registration or use in bad faith. Also, for SASI.br policy, you can rely in trademark or trade names, or even in well-known trademarks. I'm sorry if I'm going too fast. So next slide is very important for us, and we really recommend those who are willing to file with us or responding to a complaint, or they want to give advice to their clients. This is like 20 years of work in a document. So it's like we have all the elements there, and we're discussing whether a complainant can prove first and second and third elements, and also the respondent proved as rights. So it's a very important document. It was even cited in a Supreme Court lately. So it's in our webpage, the WIPO overview. And even in SASI, which is a different policy from the UDRP, panelists tend to sign the overview because it's really like a UDRP.br is a UDRP variation, and it have a lot of good discussions and jurisprudence there. So next slide is just to flag to you that in our website we have update guide to UDRP and .br. We have there the pleadings, so you can access a model complaint, a model response, and also all of our decisions are accessible for you there. And also the WIPO overview is there for you. So if you need to check anything. So next slide, I'll give some practical examples, and we'll try to give a practical approach. So here there are some .com and .br disputes. So the first element is really a standing element. So the standing test is whether a trademark is recognizable in the disputed domain name. So what you really need to focus here, if you're filing a complaint with us, is to provide a panelist with evidence that you have trademark rights or unregistered trademark rights, and that this trademark is recognizable in the disputed domain name. So here, for the first element, is not relevant if there are additional terms like privacy or marketing or Brazil. This is important only for second and third elements, but it's really important for you to provide the panelists with trademark certificates and to make your argument that the trademark is recognizable in the domain name. So next slide is only applicable for UDRP, so SASI doesn't have this second element, is that the respondent doesn't have rights or legitimate interests in the disputed domain. Some complainants argue here that is like an impossible task to prove a negative, but here you only need to do a prima facie case, so the burden of proof will be in the respondent to prove that they have rights in using or registering the domain name. Here I just put it, and you can check later, is not a .br case, but it's Brazilian parties, is .nu trademark, is a banking in Brazil. And the second level portion of the domain name doesn't have the trademark itself, but if you access the domain name, the nature of the domain name is misleading consumers with the colors and the same area of business that's a complainant. So it's a very interesting case if you want to check it out. Third element, I could stay like long hours speaking of this, is the next slide, please. Bad faith. So we see every day at WIPO that frauds are coming more and more sophisticated. So here you really, for the UDRP, you need to prove that registration and use of the domain name are in bad faith. In SASE, only registration or use, and it's really showing the panelists that there's abusive registration and use, and you should provide evidence to the panelists. It's not for the panelists' role to go after the domain name to access, and you really should provide relevant evidence. And it's really like proving that the registration and use were made in bad faith, and the registrant of the domain name is really taking unfair advantage of complainant's trademark. So the last slide, I'm citing some COVID-related cases that we received lately, and unfortunately we are receiving a lot of those. Some are like inactive cases, but some other really are reproducing fraud and having social impact. So just to let you know that frauds are developing and are following the trends, and we should really pay close attention to it. I think I followed the time, right, Laurent? Over to you.
Yes, very, very good. Thank you very much, Luisa, for this. I would really, at this stage, I would wish also to raise two questions. One to Joe and you, but mostly to Joe, and the second one to you and Joe, but mostly to you. So the first one is the following. Bearing in mind the WIPO mechanism and the ICANN procedures in general, how do you see that, or what options do exist so that torts be redressed in the field of domain names with the WIPO Center, of course, but also within the ICANN mechanism and beyond the ICANN mechanism?
Yeah, great question. I think, as I said in my final slide, options exist. So as Louisa sort of kindly pointed out, that there is the UDRP, but I think before getting to the UDRP, I think it's always useful to see if you can approach the registrant. So I spoke about the sort of the cease and desist letter. That might be one option. And another option would be to actually see if you can just purchase the domain name from the person who's registered it. Now, obviously, there are some drawbacks to this because the registrant, as Louisa said, may be a bad faith registrant. So in those instances, they may not be too open to a sort of a direct approach. I think if it was me, I'd be firstly looking at see if I can get the name back, and then if not, then go through the WIPO mechanism, as pointed out by Louisa. And then in parallel, you can still, if you have a trademark in your domain name, you can still invoke trademark infringement proceedings along with other intellectual property rights. So I think, to answer your question directly, first and foremost, see if you can get the name back without recourse to either the WIPO or IPR infringement proceedings. If not, then the WIPO proceedings would be my next best shot.
Indeed, I really share your approach, in particular because basically courts mechanisms are too slow for this purpose. But we should always remember that a good lawyer, before litigating, should still try to find whatever informal way of gentle pressure to get his rights back, basically. There is a second question that I would this time mostly address to Luisa, but also to Joe if you want so, and this relates to artificial intelligence. Okay, with the explosion of domain names, with the fast development of domain names, Gustavo Castro, rightly from ABAPI, points out that WIPO is engaged into studying mechanism procedures using artificial intelligence to facilitate the domain name procedures. So first question to Louisa, could you tell us more about this? And second question to Louisa and Joe, are there also other initiatives in this respect worldwide?
Thank you, Lahan. Well, from a domain name perspective, we now offer UDRP resolution services. So we need, when filing with us, we are managing these contractually mandated procedures. So this alternative dispute resolution procedure implemented by ICANN, but we are managing these proceeding, and we are appointing a panelist who is an expert in domain names, who has like a huge career and experience in domain names. So we're still appointing experts and specialists in domain names. So for now on, from a domain name perspective, we are still working on a case-by-case basis. We're still treating the cases and analyzing and going through the whole process, which is the UDRP policy. So we follow requirements and elements and rules. And for a domain name UDRP provider, we're still following this practice. Maybe in the future we'll find a machine to do it for us, but it's really case-by-case basis, and it's something that we follow the UDRP rules, and we appoint impartial and a neutral panelist to decide the case, which will go through the whole case file, will read all the documents and go through all the evidence that complainant and respondent submitted. So for at this stage, we are still counting on the power of human analysis and judgment for this.
Yeah.
Thank you very much. Joe, you want to add something or comment on this?
I was just going to say that I think that's a really, really important and interesting question, but the impact of artificial intelligence we're already seeing on intellectual property offices across the world. We are seeing, for instance, intellectual property offices using AI systems to analyze prior art when making decisions about patent applications. So I don't think it's too much of a step for artificial intelligence to start looking at decisions made by WIPO in relation to domain name disputes, and to start making pretty strong predictions as to what decisions would be. Now, if that does happen, which I'm sure it will eventually, then I think AI will be, you know, depending upon the amount of data it has from which AI then learns about these decisions, to actually start making some appropriate predictions. And that has huge benefits for individuals or companies who are making applications under the UDRP, because they may have an idea already before they make an application as to whether it be successful or not. That's if I've understood your question correctly.
This is actually one of the ways to understand it, as the question came from Gustavo Castro. So yes, determining probabilities, making what we call algorithm in law, which is something absolutely fascinating. There is also a second approach, which is, of course, the neutrality of the panelists. We know that in some countries, for example, in the US, and Professor Catherine Rogers from Penn State School of Law and Queen Mary in London, there is a program that has been launched to using artificial intelligence to ensure transparency in the choice of arbitrators, transparency and neutrality, which is also a way where artificial intelligence can be used. So there are many formats, and I am happy that Luisa, you and modestly your moderator could talk on it, but I think there are many projects all around, of course, with a strong lead on the WIPO ones. If there is also an additional question, a fascinating question coming from Brazil, that relates to the costs of appeals against UDRP decisions. That means court appeals. There is the need of going to a jurisdiction. There are the costs that are connected to choosing a jurisdiction and then to conducting a trial in the same jurisdiction. Could we imagine, could we envisage in a second stage that WIPO develops an appeals procedure? That means not a uniform dispute resolution as such, but an appeals mechanism on dispute on a UDRP that would permit, therefore, to alleviate the costs and ensure legal certainty and enforceability. The question is to both, but mostly perhaps to Luisa.
So this is a great discussion, which is going on for years, whether the UDRP should have an appeal procedure. So first of all, we're talking here WIPO as being a UDRP provider. So the UDRP is a policy implemented by ICANN, and what WIPO does is just following the rules and the policy. So the discussion is whether the UDRP will have space to accept appeals and so on. And this is a huge discussion ICANN is having, and we do have this in our annual meetings. But for now, we don't have this mechanism. Parties need to go to court if they don't agree with the panelist decision. This is something that allows the proceeding to be fast. So the UDRP proceeding lasts around 65 to 75 days. So it's an expedited procedure, and once you receive a decision, either transferring or denying the case, you have 10 business days to go to court. So most of the cases, they don't get to court because they are judged by panelists with huge experience in domain names, and the work that has been done by WIPO as a UDRP provider, it's like a really case of success. I don't know if we have filers with us here today, but it's a really a lot of work we put on it, and we really we have great feedback. So for now, we don't have the appeal system. Parties need to go to court. Of course, it's going to be costly and time consuming, but the other way around, like the proceeding is very effective, and it's only effective because we have time deadlines. So if, for example, a company is the target of a registered domain name abuser or cyber squatter, which is sending fraudulent invoices or fake emails, and the consumers are also are really sending out money, and the company is losing money every day. So it's very important here in the online environment that we have expedite procedure that doesn't take too long, because every day is a lot of money that's going on in the online environment. It's kind of different than the physical environment. So for now, we still don't have this appeal process, because I think this would add some extra days in the procedure. And right now, we're fixed in being a expedite procedure. So no, we still don't have this appeal process, but hopefully you won't need to go to court. You can file with us.
Yes, indeed. One must consider that the WIPO Mediation and Arbitration Center launched the domain name resolution mechanism precisely to eliminate the most blatant cases, the cases where we absolutely need basically to eliminate those who fraud, who blatantly fraud, and for the others, okay, there are also the appeals procedures. It is right that with the strong development of intellectual property litigation and also of domain names, now perhaps an additional stage may be requested, in particular by business circles. Some governments may be reluctant, but no doubt that there is a business pressure for this.
Laurent, I have a quick question on the trail of the previous question to Louisa. Is there any kind of statistics of how many cases end up in court?
We keep a record of this, but I think we don't have these stats in the website, mostly because this is like kind of confidential. But I'm gonna check, and maybe the person who asked this can drop me an email, and then
In fact, question is mine.
So you call me and.
Based on what you said, the need for the appeals will directly depend on the number of questions, decisions that were taken further to court.
Yeah, we are, well, the WIPO's role ends when the decision is rendered. So implementation issues and court proceedings, this is outside of the UDRP provider role, but we ask, and normally we do, it's the complainant or the respondent will let WIPO know, or the UDRP provider, when a court action is initiated. We publish all the stats we have about cases and filers and countries. So I don't know if we have this, but I'll check and I'll let you know if anyone can drop me an email.
Yes, indeed, this is a major issue, which of course brings clearly the strengths, but from an academic point of view, the limits of the mechanism, in the sense that the enforcement lies with national authorities. And because there is the enforcement lies with national authorities, yes, in a way or another, national enforcement mechanisms, courts, justice, police, must be involved. So this is one of the normal limits of the system, where it can't go too far in this very sense. But this is what is done is already a major step. Oh, it is, in fact. You want to add something, some comment to this?
I was just going to say that it's about striking a balance, isn't it? Can you hear me?
Yeah. Yes, perfectly.
I was just saying it's about striking a balance. So, you know, Louisa made a very good point that it's about expediting decisions, you know, so that a company that may be losing, you know, funds and money to a third-party bad faith registrant needs that domain name back, or at least suspended as soon as possible. But however, as the disputes become more subtle, and they're not just about flagrant breaches, as Lauren said, you know, where you have an obvious good person and a bad person, then I think having some sort of appeal mechanism, which also deals with the sort of the potential impartiality issue that we referred to earlier, is something that WIPO possibly does need to consider in the medium to long term.
Very, very good. Are there additional questions?
There is one question. There's one question that was just posted here. It's in Portuguese. I'll try to translate. It's from Carlos Assissoni from the Brazilian Patent and Trademark Office. His question is, in conflicts where concerning domain names and trademarks, can the conflict be centered in the generic characteristics of the domain name? The transfer, the transfer of the domain name to a more specific one can erase, can solve the problems in some cases. I think it's this. Or in Portuguese, for Luísa, em conflitos entre nomes de domínio e marcas, o conflito pode estar centrado no caráter genérico do nome de domínio. A transferência do nome de domínio mais específico como .br pode sanar alguns casos. A transformação, ele corrigiu agora. So the transformation of this domain, which would supposedly be .com, into a more specific, like a country code domain name, can solve some of the problems, some of the issues of a more generic domain word in the domain name. I think it's this.
Okay, let's see if I understand. So in case that it's a generic word in a domain name, which is also a trademark, if this is like inside the scope of UDRP, and if adding a country code top level domain name, if it would make it like not infringing.
Yeah, I think that's the question. If the domain name is also a generic word, which would be the center of the issue, the trademark or the generic portion of the domain name?
Okay, so this is really a case-by-case analysis, but the UDRP, the elements, they are cumulative. So the first element is a standing requirement. So you need to have a trademark to file an unregistered trademark or common law rights to file a complaint with us. In the case that you have a trademark that somehow is also generic word, like for example, Apple. Apple is a trademark and is a generic word, right? But this is the first requirement of a UDRP case. You still have to prove that the registrant of the domain name doesn't have rights or legitimate interest in using that domain name, and that the registrant is also had registered and used the domain name in bad faith. So if you have a generic word, which is a trademark, the domain name that you're trying to get transferred or canceled needs to be infringing your trademark in some way. So it needs to have bad faith in there. So this is kind of what we are dealing at WIPO Center with abusive registrations. If you have a trademark which is generic and third party acquires a domain name which matches your trademark, but it's also like a generic term and it's a valuable domain name, and the person is not like targeting your business or market or your clients, it will be difficult to satisfy the third element, right? Because you need bad faith. You need the third person abusing your trademark. So Apple, of course, it's a simple example. But if you go through the domain name that is incorporating your trademark, which is a generic term, it really needs to have bad faith. So if you enter the website and you have your logo, or if you have your address or your colors, really your case should be, you only bring your case to WIPO only if you satisfy the three elements. And if you're adding SSCTLD to it, the first element analysis, and it's a tricky question because the second example I gave, pagi.nu, the trademark is actually in the extension, so the .nu, which is a ccTLD. But normally the analysis will not count the extension because this is a technical component of a domain name. So normally you need to have a .com, a .co, a .nu. This is the technical part of, I'm trying to translate. So so this is sometimes doesn't enter in the analysis of if the trademark is recognizable in the domain name, but sometimes it does, like in the example I did. So it's hard to answer this question because it's really a case-by-case analysis, and it's hard to put like a strict logic to it. But I don't know if I answered. Please send me a feedback if I answered you correctly.
Yeah, now he's saying here that you answered exactly what he wanted to know.
Good.
If I could add just one comment to that, I was going to say, if you take the trademark aspect out of the equation, and you've got two domain names, sorry, a domain name which two parties are fighting over effectively. I have seen certain companies who keep hold of the domain name, but then just put a caveat on the website to say that we have no connection with the other company, with the other party. And so that deals with the point of, deals with the bad faith element of it, because then the bad faith can't be proved if they've got that caveat there. Does that make sense?
Yeah. So we have, this is another huge discussion. I think you're referring to resellers or distributors. We have many cases of resellers, or even Philip Morris, they file a lot of, with us because they have many websites that sell their products, and they add like a little disclaimer on the bottom of the page. So to be able to keep these domain names, or in other words, to be able to establish the Wikidata test, which is one case that became famous and is also in our overview. And you really need to establish 4 requirements. So you cannot corner the market, for example. You need to disclaim or to clarify the relationship between the trademark owner and the website. So in our overview, I don't know by heart now, but in our overview, if you search for Wikidata, you will find a whole section about this, about resellers or authorized distributors, sorry. And you really need to fulfill some requirements to be able not to mislead consumers, right? So, but access our overview, and it's, everything is out there. Just, I don't know if it.
Yes, I think this is a very important comment that that you made, Louisa and Joe, on this. I would just wish to add that one of the bases for this approach lies within WIPO old decision, which is Port of Helsinki, where there were elements of generic character and of national declination. Port of Helsinki, Port of London, Port of Rio, and so on, from this website Port of, which opposed the Port of Helsinki to the owners of the website Port of being clearly generic, but being not generic anymore when associated with Port of Rio de Janeiro. So in this very case, we find there one of the key elements that has paved successive cases in this very respect. But of course, this is for, as Riza has rightly pointed out, and together Joe as well, this is with the top, the generic names, the top level domain names. Then with the national ones, national jurisdiction, we have most countries going now to WIPO, but there are still other options in order to fight the genericity of a domain name. So in this very case, when Joe has mentioned earlier that, okay, the best option is WIPO, of course it's WIPO, but if you are in the national names, you may well file national to courts as well. So no doubts on this, no doubt on this. There is another very beautiful question or request for being more detailed on this, coming from Luisa Hastlancina. And actually, she requests us, Mariana Hastlancina requests us to be more precise on the elements of anteriority in the domain name. Should anteriority in so first arrived, first served be the principle, but connected to this, should there necessarily be bad faith? And Luisa has already mentioned this, but I think Luisa may wish to further elaborate on this question of the bad faith, since one of our participants in our audience requests whether bad faith is really, really compulsory in order to get the domain name cancelled.
I will see if I can questions, but no, right? I think only you.
Luisa?
Hi.
You understand? The question? Yeah.
So registration in bad faith, right?
Yeah, registration bad faith. Basically, is bad faith absolutely necessary to cancel or transfer a registration? To me, it seems so. I suppose to Joe as well, but as our public has requested us, could you please slightly elaborate on this very point? Thank you.
So if we are discussing UDRP, like generic top-level domain names, and some ccTLDs like .co for Colombia adopts UDRP, and some other, registration in bad faith is necessary. So there are many ways for the complainant to argue that the respondent was aware of the complainant and of the complainant's trademark when registering the domain name. This is something we have some situation in the overview, but for the UDRP, yes, it's mandatory to prove registration, or in other words, registration in bad faith, or in other words, that the respondent had the complainant's trademark in mind when registering the complaint, the domain name. For SASI.br policy, it is not necessary if you prove use in bad faith. So you only need to establish registration or use in bad faith. And some other ccTLD policies, also like .mx, if I'm not mistaken, adopt like registration or use. So it really depends from the policy, but UDRP, yes, you need to prove both registration and use in bad faith.
Very, very good. At this very stage, as we have no additional question from the public, and it's already quite late, webinars could not last too long, otherwise the audience would be bored. So we hope not to have been boring. I would wish to leave the floor to Ricardo, who may wish to make some comments. ABAPI has been a very generous host of us today, of WIPO and the Transatlantic IP Academy. So I would really enjoy if Ricardo would make some closing words or some closing remarks and questions again before we formally close.
Thank you, Laura. I think it was a very clear and objective discussion. As I mentioned in the beginning, for more than 20 years now, this system has been working very well. And the number of cases has never diminished, because when it began back in 2000, 2001, was a boom of cases that were there pending a way of a quick decision, and they were expected to be not ended but diminished a little bit. And no, the number of cases has in fact increased. As Laurent also mentioned, WIPO has a very good system of dispute resolutions following ICANN proceedings, and also SASI, which is the Brazilian system. There are also other chambers that perform the same locally, the same service as well, depending on the country, or .com also. For instance, the Brazilian Association for Intellectual Property has a chamber. In Brazil, there are 2 other chambers of commerce that perform the same service, but they all work very well, and the system is very fulfilling. And that's why I placed that question to Luisa on the number of decisions that were taken to court, because maybe I'm optimistic, but I think that the number is not as high as capable to justify another system of appeals within the system. But since I don't have the number, I'll have to rely on my suspicion. Since there are no other questions, I'd like to thank Laurent and José Graçaranha and Joe Sicorn and Luisa Berbiger for the presentation, and hope to see you again soon in another webinar as profitable as this one. Thank you and good night. Boa tarde a todos e até o próximo. Luisa, diga.
Boa tarde a todos, and all the very, very best to our Brazilian friends from the Transatlantic IP Academy. We are grateful to WIPO and ABAPI for this splendid cooperation, and we thank warmly our speakers, José Con and Luisa Berbiger.
And then we have José Graçaranha again.
Yeah, again, of course.
Thank you, Laurent. Well, I've been following. I was following, of course, without the camera, so that I could. The sign would be
the silent follower.
Thank you very much, Laurent.
Of course.
Thank you very much, Laurent. Thank you, Alvaro. It was an excellent event. We will continue with these events, and between the association, the Transatlantic IP Academy, and WIPO, we hope to continue and to have more and more events in these difficult times. And thanks for the speakers, and see you next time. See you soon.
And if someone lost the beginning or a part of it, can go back to the YouTube ABAPI page and hear it all over again.
Thank you.
Thank you. Bye. Obrigado.
Bye.
Ciao.
Bye-bye.
All the very best.